So let's think about case analysis. I hope in this micro lecture just to give you an introduction as to how you need to adjust your thinking. So when you get your case papers, there are one or two things that are always going to happen. So first of all, whatever the subject, there will be lots of facts, and whether it's a drafting exercise or opinion writing exercise or an advocacy exercise, you'll have facts that are given to you in the statement, documents and evidence that you're given in your case papers. And you need to understand those facts. Now, because you're given those facts in a written form, there may be things that aren't dealt with, or facts and information that you don't know. And so you quite often find that you've got a lot of the facts, but not all the facts. So there's always something wrong. You don't have as much information as you'd like to have had if you had spoken to a person and they were right in front of you and you could ask them all the questions that you wanted to. The second thing to remember is that in addition to not having all the facts, sometimes you get to the position where you don't have all the evidence. So evidence is normally given in the form of a statement or a document, a photograph, a sketch plan, and it may be that you're asked to do a task, but in order to do that task, you may not have a diagram, you may not have an expert's report, you may not have all the statements that potentially are out there that you need to consider. And the third thing that you need to remember is that sometimes there are gaps in the information that you're given. So you might read your case papers and you think, well, actually, I want to know a bit more about B, but there's no information. You're given a statement and it covers a lot of information about A, but B is very, very superficially dealt with or not at all. And then finally, the other thing that you've got to remember is that once you are asked to do a task, you've got to do that task to the best of your ability, even though you may not have all the facts that you want, all of the evidence that you would ideally like, and that there may be some gaps in the information that you've been given. And that process of trying to make a decision when things aren't perfect is called case analysis. Okay, so moving on to my next slide. There are a couple of things that you should always try to think about when you're doing your preparation. Now, clearly you'll be told in your papers that you're instructed to act on behalf of a specific party. And that party, through their witness statements, will explain what happened and what the problem is. And you will read that information and work out in law what their story is and what the legal case is for that client. But you have to always remember that in order for there to be a dispute, there's always got to be at least two parties to any dispute. So your opponent has a view, and you have to understand that view. So let me give you an example. You've been told by your client that they purchased some goods in a contract, and there's a written contract, let's make it easy, and the goods were delivered, but they don't meet the specifications, and they paid for the goods in advance, and they want their money back. And your job is to provide a legal advice, an opinion. It transpires from the correspondence that you see between the two parties that the opponent believes that they have delivered the goods that were required under the contract and they've been paid for them, and they don't see that there's been any breach of contract, and as far as they're concerned, contract's been performed. That's the end of the matter. Now, if you don't understand what your opponent is saying, then it's very difficult for you to advise your client, because you're not going to give a fair and independent and impartial advice if you haven't taken into account the views of the opponent. So what you're trying to do when you do case analysis is weigh up the strengths and weaknesses of your client's case against the arguments and strengths and weaknesses of your opponent's case. So if you've only just looked at the strengths of your client's case, you're not really giving your client a fair, realistic analysis of their case. Part of understanding the strength of your client's case is understanding the weaknesses, but at the same time, understanding the strength and weaknesses of your opponent's case and working out that balance. So the stronger your client's case is, maybe they have very good evidence, they have an expert's report, the arguments make a good case in law. Great. It usually means the weaker your opponent's case is. And the more evidence your opponent has, the stronger their case is in law, then it tends to suggest that your client's case is going to be weaker. And it's a balancing act. Sometimes it's very finely balanced between two cases, or between your client and their opponent. If you simply accepted everything that your client said as absolute truth and thought, all right, I'm going to accept all of their evidence, I'm not going to look at what the opponent has to say because I'm instructed by this client, you'll get a very distorted view of the strength of your client's case. And that's why we have to do that analysis between what your client has to say and their evidence and what your opponent has to say and their evidence. And that's a new thing that you may not have done when you studied your law at undergraduate level. But remember, on the bar training course, you're moving from just discussing law as an academic subject to understanding how to advise a client in a vocational course where you're taking your understanding of the basic principles of law, applying them to specific facts that you've been given in your case studies, looking at the evidence you've been given, and then carrying out a task to help and advise your client. So, for my next slide, one of the things that students often struggle with is making that decision because it's not a science. There's no mathematical formula. What you're trying to do is to explain to your client why you think X or Y. Okay? And lots of students struggle with that. And what some of them do is decide, okay, this is all too complicated. I don't have enough facts. I have some evidence that's missing. I think I need an expert's report to help me out here to make a better decision. Oh, and there's so much gaps in the information that I've got. I'm not going to make a decision. So imagine that you as a lawyer have been asked to advise somebody on a legal issue. And there was no point in them asking a lawyer to advise unless there's a problem or a complication. Somehow the law is not straightforward. Otherwise, why wouldn't the instructing solicitors just deal with it? And you come back with the legal opinion saying, I can't make a decision. The client's going to say, well, why am I paying this lawyer to tell me that they can't decide at this stage? So being in that scenario where you can't make a decision is not a good place to be. The other alternative is some students think that it'd be really good if I just said what my client wants to hear. So if the client in their witness statement says, I think I have a good claim in contract and I want to sue this person for breach of contract, and they think, well, okay, that's exactly what my client wants. I'm going to tell them they've got a great case, because if everything they say is right, they could have a great case. But that is not really analysing the strength and weaknesses of your client's case and of your opponent's case. So it doesn't really work well. The other alternative is just a guess. Well, I'm not sure, it could be this, it could be that. Okay, I'm not sure which one I should choose. I don't want to commit. Okay, so what I'm going to do, I'll just guess because there's a 50% chance I could be right. Now, the difficulty with that approach is there's a 50% chance you could be wrong, and your client's going to ask you to explain why you came to that decision. And if you can only say, well, I came to the decision you have a great case because I guessed that's not going to get you any points in the assessment. And ultimately, you do want to pass this course. Another approach that sometimes students take is to decide, okay, I don't have all the facts, I don't have all the information, but what I can do at this stage is assume that my client will provide me with information that will make this case brilliant. So I will assume that all the gaps in information that I have at the moment, my client will provide a statement from somebody and that statement will be very positive. I will assume that my client will get an expert's report and I will assume that expert's report will be favourable. And then when I've assumed further evidence, an expert's report, I'm going to assume that this is a great case, because I'm going to assume the expert evidence is positive, the witness evidence is positive, and they'll get some other documents to help them. And I'm going to give them the legal advice that this is a great case. Well, it doesn't work like that. Sometimes you can make little assumptions. If someone has given you something in a witness statement to suggest that there's another document that exists, you can assume that they'll be able to obtain it. But you can't assume that the content of that document will say X, Y, Z, unless somebody said they saw it and did say X, Y, Z. So you can't make all of these leaps into assuming everything's perfect so you can manufacture a very positive case for your client. And that's particularly true in advocacy when you're making an application to the court and there's some information missing. You can't mislead the court, you can't make assumptions and assume that this will be proved or that document exists or it says X, Y, and Z. Okay? You've got to deal with the facts as you have them and the evidence as you have it and put forward the best case you can for your client. But you can't make things up and you can't make wild assumptions. The last and final thing to do is to analyse the information that you've got, to look at the evidence, to compare it and contrast it with the evidence your opponent has, to find out if there are documents, diagrams, photographs, expert evidence that corroborates your client's version of what happened and undermines your opponent's version of what happens. And then having done all of that and being able to explain why you have come to a decision, you come to a clear decision and conclusion. And that is case analysis. The case analysis is that big process in the middle, from getting your instructions to being able to advise your client and complete a task. And this bit, all in the middle, your analysis of what you're reading, the evidence that you've got, your understanding of the core principles of law, all of that is case analysis. And case analysis allows you to do the task that you've been asked to do in your instructions. So I hope case analysis makes some sense to you. It's really interesting process. And we're going to talk in the next micro lecture about how you start off the process of analysis. And it really starts off with your reading. Once you get your reading into the right spot, then it helps you to start to be able to evaluate the information. I'm Suzanne Reece, the study coach. If you like the video, please subscribe to it.